it's Kim. Hope y'all had a good weekend. I've been busy dealing with a lot of things, so hopefully I can continue just do my recordings. But anyway, this is a document of the Jeffrey Epstein, one of the lawsuits. I think there were some people trying to basically make sure information was made available to the public. I believe that's what the point of this is. It's like 2,000 pages of stuff, y'all. So it may take a while to get through this, but anyway, let's get going here. I don't know if people are still super interested in this. I'm not going to let it go, but it is what it is at this point. Um, but it's kind of fascinating to look through these documents. Just it really is. But anyway, so let's go on. So it says, while the law governing public access to these materials is largely settled, we have not yet adequately addressed the potential harms that often accompany such access. These harms are apparent. Over 40 years ago, the Supreme Court observed that without vigilance, courts' files might become a vehicle for improper purposes. Our legal process is already susceptible to abuse. Unscrupulous litigants can weaponize the discovery process to humiliate and embarrass their adversaries, shielded by the litigation privilege. Bad actors can defame opponents in court pleadings or depositions without fear of lawsuit and liability. Unfortunately, the presumption of public access to court documents has the potential to exacerbate these harms to privacy and reputation by ensuring that damaging material irrevocably enters the public record. We therefore take the opportunity to describe the tools available to district courts in protecting the integrity of the judicial process and emphasize the court's responsibility to exercise these powerful tools. We also caution the public to critically assess allegations contained in judicial pleadings. And then there's footnotes. So a standard of review. When reviewing a district court's decision to seal a filing or maintain such a seal, we examine the court's factual findings for clear error, its legal determination de novo, and its ultimate decision to seal or unseal for abuse of discretion. The summary judgment materials. With respect to the first category of materials, it is well settled that documents submitted to a court for its consideration in a summary judgment motion are, as a matter of law, judicial documents to which a strong presumption of access attaches under both the common law and the First Amendment. In light of this strong First Amendment presumption, continued sealing of the documents may be justified only with specific on-the-record findings that sealing is necessary to preserve higher values, and only if the sealing order is narrowly tailored to achieve that aim. And more footnotes. If you want to stop it and read those, it's fine. Okay, do whatever. It just takes a lot longer to get through these. That's why I don't read them. But anyway, in this case, the district court erred in several in several respects. First, it failed to give proper weight to the presumption of access that attaches to documents filed in connection with summary judgment motions. The district court reasoned that the summary judgment materials were entitled to a lesser presumption of access because summary judgment was denied by the court. In assigning a lesser presumption to such materials, the district court relied on a single sentence of a dicta from our decision in United States versus Amadeo. We have since clarified, however, that this sentence was based on a quotation from a partial concurrence and partial dissent in the D.C. Circuit, and is thus not the considered decision of either this court or the D.C. Circuit. In fact, we have expressly rejected the proposition that different types of documents might receive different weights of presumption based on the extent to which they were relied upon in resolving a motion for summary judgment. Second, in the contravention of our precedent, the district court failed to review the documents individually and produce specific on-the-record findings that sealing is necessary to preserve higher values. Instead, the district court made generalized statements about the record as a whole. This too was legal error. Finally, upon reviewing the summary judgment materials in connection with this appeal, we find that there is no countervailing privacy interest sufficient to justify their continued sealing. Remand with respect to these documents is thus unnecessary. Accordingly, and to avoid any further delay, we order that the summary judgment documents with minimal redactions be unsealed upon issuance of our mandate. And then there's more stuff there. All right, and the remaining sealed materials, the law governing disclosure of the remaining sealed material in this case is only slightly more complex. The Supreme Court has recognized a qualified right to inspect and copy judicial records and documents. In defining judicial records and documents, we have emphasized that the mere filing of a paper or document with the court is insufficient to render that paper a judicial document subject to the right of public release. Instead, the item filed must be relevant to the performance of the judicial function and useful in the judicial process in order for it to be designated a judicial document. As our precedent makes clear, a court performs the judicial function not only when it rules on motions currently before it, but also when properly exercising its inherent supervisory powers. And there's a bunch more footnotes. The document is thus relevant to the performance of the judicial function if it would reasonably have the tendency to influence a district court's ruling on a motion or in the exercise of its supervisory powers, without regard to which way the court ultimately rules or whether the document ultimately, in fact, influences the court's decision. Accordingly, if in applying these standards, a court determines the documents filed by a party are not relevant to the performance of a judicial function, no presumption of public access attaches. Once an item is deemed relevant to the exercise of judicial power, the weight to be given the presumption of access must be governed by the role of the material at issue in the exercise of Article 3 judicial power and the resultant value of such information to those monitoring the federal courts. Thus, while evidence introduced at trial or in connection with summary judgment enjoys a strong presumption of public access, documents that play only a negligible role in the performance of Article 3 duties are accorded only a low presumption that amounts to little more than a prediction of public access absent a countervailing reason. Documents that are never filed with the court but simply pass between the parties in discovery lie entirely beyond the presumption's reach. The remaining sealed materials at issue here include filings related to inter alia, alia, motions to compel testimony, to quash trial subpoena, and to exclude certain deposition testimony. All such motions, at least on their face, call upon the court to exercise its article powers. Moreover, erroneous judicial decision-making with respect to such evidentiary and discovery matters can cause substantial harm. Such materials are therefore of value to those monitoring the federal courts. Thus, all documents submitted in connection with and relevant to such judicial decision-making are subject to at least some presumption of public access. More footnotes. Okay. Although a court's authority to oversee discovery and control the evidence introduced at trial surely constitutes exercise of judicial power, we note that this authority is ancillary to the court's core role in adjudicating a case. Accordingly, the presumption of public access in filings submitted in connection with discovery disputes or motions in limine, I guess that's how you say it, is generally somewhat lower than the presumption applied to material introduced at trial or in connection with dispositive, whatever motions, such as motions for dismissal or summary judgment. Thus, while a court must still articulate specific and substantial reasons for sealing such material. The reasons usually need not be as compelling as those required to seal summary judgment filings. Here, the precise basis for the district court's decision to deny the motion to unseal these remaining materials is unclear. In the 3 paragraphs devoted to the issue, the district court emphasized the potential for embarrassment given the highly sensitive nature of the underlying allegations, and concluded that the documents sealed in the course of discovery were neither relied upon by the district court in the rendering or in adjudication or of an adjudication, nor necessary to or helpful in resolving a motion. It is therefore unclear whether the district court held that these materials were not judicial documents and thus are not subject to a presumption of public access, or found that privacy interests outweighed a limited right of public access. On either interpretation, however, the district court's holding was error. The district court's holding was error. Insofar as the district court held that these materials are not judicial documents because it did not rely on them in adjudicating a motion, this was legal error. As explained above, the proper inquiry is whether the documents are relevant to the performance of the judicial function, not whether they were relied upon. Indeed, decision makers often find that a great deal of relevant material does not ultimately sway their decision. And insofar as the district court held that privacy interests outweigh the presumption of public access in each of the thousands of pages at issue, that decision, which appears to have been made without particularized review, amounts to an abuse of discretion. In light of the district court's failure to conduct an individualized review of the sealed materials, it is necessary to do so now. We believe that the district court is best situated to conduct this review. The district court can directly communicate with the parties and can therefore more swiftly and thoroughly consider particular objections to unsealing specific materials. Relatedly, the district court can obtain the parties' assistance in effecting any necessary redactions and in notifying any outside parties whose privacy interests might be implicated by the unsealing. Accordingly, we remand the case to the district court to conduct such a particularized review and unseal all documents for which the presumption of public access outweighs any countervailing privacy interests, protecting the integrity of judicial proceedings. While we disagree with the district court's disposition of the motion to unseal, we share its concern that court files might be used to promote scandals arising out of unproven, potentially libelous statements. We therefore describe certain methods courts can employ to protect the judicial process from being co-opted for such purposes. The Supreme Court has explained that every court has supervisory power over its own records and files to ensure that they are not used to gratify private spite or promote public scandal or serve as reservoirs of libelous statements for press consumption. This supervisory function is not only within a district court's power, but also among its responsibilities. In practice, district courts may employ several methods to fulfill this function. They may, for instance, issue protective orders forbidding dissemination of certain material to protect a party or person from annoyance, embarrassment, oppression, or undue burden, and require that filings containing such material be submitted under seal. If parties then seek to file such materials, the court may deny them leave to do so. District courts may also seek to counteract the effect of defamatory statements by explaining on the record that the statements appear to lack credibility. Moreover, under Federal Rule of Civil Procedure 12F, the district court may strike such material from the filings on the grounds that it is redundant, immaterial, impertinent, or scandalous. Because such rejected or stricken material is not relevant to the performance of the judicial function, it would not be considered a judicial document and would enjoy no presumption of public access. Finally, in appropriate circumstances, district courts may impose sanctions on attorneys and parties under Federal Rule of Civil Procedure 11C. And the cautionary note, we conclude with a note of caution to the public regarding the reliability of court filings such as those unsealed today. Materials submitted by parties to a court should be understood for what they are. They do not reflect the court's own findings. Rather, they are prepared by parties seeking to advance their own interests in an adversarial process. Although affidavits and depositions are offered under penalty of perjury, it is in fact exceedingly rare for anyone to be prosecuted for perjury in a civil proceeding. Similarly, pleadings, complaints, and briefs, while supposedly based on underlying evidentiary material, can be misleading. Such documents sometimes draw dubious inferences from already questionable material or present ambiguous material as definitive. Moreover, court filings are, in some respects, particularly susceptible to fraud, for while the threat of defamation actions may deter malicious falsehoods in standard publications, this threat is non-existent with respect to certain court filings. This is so because under New York law, which governs the underlying defamation claim here, absolute immunity from liability for defamation exists for oral or written statements made in connection with the proceeding before a court. Thus, although the act of filing a document with the court might be thought to lend that document additional credibility, in fact, allegations appearing in such documents might be less credible than those published elsewhere. More footnotes. Okay, we have long noted that the press plays a vital role in ensuring the public right of access and enhancing the quality and safeguards the integrity of the fact-finding process. When faithfully observing its best traditions, the print and electronic media contributes to public understanding of the rule of law and validates its claims of functioning as surrogates for the public. At the same time, the media does the public a profound disservice when it reports on parties' allegations uncritically. We have previously observed that courts cannot possibly discredit every statement or document turned up in the course of litigation, and we have criticized the use by the media of the somewhat misleading term court records in referring to such items. Even ordinarily critical readers may take the reference to court papers as some sort of marker of reliability, and this would be a mistake. We therefore urge the media to exercise restraint in covering potentially defamatory allegations, and we caution the public to read such accounts with discernment. In the conclusion, to summarize, we hold as follows. Materials submitted in connection with the motion for summary judgment are subject to a strong presumption of public access. The summary judgment record at issue will be unsealed upon issuance of our mandate, subject to minimal redactions. Materials submitted in connection with and relevant to discovery motions and motions in limine and other non-dispositive motions are subject to a lesser but still substantial presumption of public access. The district court is directed to review the remaining sealed materials individually and unseal those materials as appropriate. And district courts should exercise the full range of their substantial powers to ensure their files do not become vehicles for defamation. For the foregoing reasons, we vacate the orders of the district court entered on November 2nd, 2016, May 3rd, 2017, and August 27th, 2018. Order the unsealing of the summary judgment record as described herein and remand the cause to the district court for particularized review of the remaining materials. In undertaking this task, the district court may be well served by ordering the parties to submit to the court unredacted electronic copies of the remaining sealed materials as well as specific proposed redactions. The district court may also order the parties to identify and notify additional parties whose privacy interests would likely be implicated by disclosure of these materials. In the interest of judicial economy, any future appeal in this matter shall be referred to this panel. All right, I'm going to stop it here. And we're on page, well, it's just page 30, but anyway, well, at least in my counter. But I'll try to maybe record another few 15 pages, whatever. And then we'll see from there what we can do. But anyway, since this is a long document, but yeah, I'm not letting the Epstein stuff go, just so you know. But anyway, I will talk to y'all later. Have a good one. Bye.